Thank you all for joining us virtually for an AMA with our Credmark co-founder, Paul Murphy. We're going to have a conversation today about global legal strategies in the DeFi space and in crypto in general. So Paul, do you want to quickly introduce yourself to everybody?
Sure. My name is Paul Murphy. As Collier just said, I'm one of the founders of Credmark. I mentioned yesterday in the founders AMA, I'm responsible for a lot of the legal work at Credmark. I've done a lot of work to make sure that we have the right structure in place to get this DAO off the ground and eventually running on its own. So Neil, our CEO, thought this would be something that people might be interested in. They might want to hear how we went about this. If they're planning on running a project or starting a project, they might be interested in having an idea of where we started from a legal perspective. So Collier, thank you for getting up so early to host this, and ask away.
It's a pleasure. So first question, global legal strategy seems super broad. Isn't this kind of an ambitious AMA to jump in on?
Yeah, that's ambitious would be one way to put it. I mean, it's a little crazy. When you think about a legal strategy, you have to take so many things into account, and the first one is where you're based. And there are literally hundreds of legal jurisdictions on the planet, right? If you take just the number of countries, there's about 200 countries in the UN. The US, in addition, has 50 states. Each one of those is a legal jurisdiction. Those are sometimes broken down into smaller pieces. A city like New York has its own crypto laws. So if you're starting a project in New York, you have to worry about what New York City thinks, what New York State thinks, what the US feds think, et cetera. Switzerland's divided into cantons, et cetera, et cetera. So yes, this is ambitious, but there are lots of basic things that you have to think about and take into account, no matter what jurisdiction you're in.
If there's basic things, can you just talk a little bit about why this might be interesting to folks? You spoke that there's basic things that we'd have to do everywhere. Why do you think folks should understand this?
Well, so there are two things that can affect the outcome of a project. One, of course, are taxes. So you probably, if a DAO raises a lot of money, or an organization that's managing a DAO raises a lot of money, you probably don't want the government to take most of that away if it's just considered income. The other, of course, are regulations. So depending on where you are, you may be subject to regulations, and if you don't follow those, you could end up paying huge fines. Right? We saw this happen with projects during the ICO boom in 2017. The SEC decided that a lot of those projects ran afoul of their regulations and came down like a ton of bricks, fined some of these projects millions, sometimes tens of millions of dollars. So it's much better to think about these things before the regulators come knocking at your door.
Yeah, that makes a lot of sense to protect yourself in a sort of shifting legal environment in the world of DeFi. With that said, can you dig into some of the types of regulation you're considering, either current or future, for Credmark?
Sure. So yeah, so I'll just talk about it from our perspective, and then anybody listening to this is going to have to take their own circumstances into account. So in our case, we have some presence in the U.S. We have people working on the protocol who are based in the U.S. The company from which this project spun out is based in Singapore, and we also have presence in the Cayman and BVI. So those are four vastly different jurisdictions. And so I can sort of talk about how certain things are thought of in each one of those. So starting with regulation, if let's start with the U.S. First of all. There are quite a few regulators in the U.S. who are involved in anything related to crypto. The SEC is just one, and the U.S. is extraordinary as a country in the sense that it has influence all over the world. So what the U.S. does or what the U.S. wants tend to affect people no matter where they live, and that's true from a regulatory perspective, and it's true from a tax perspective. This isn't a problem that most people have to deal with. If, for instance, you are Singaporean and you are running a project in Singapore, you really have to worry about the Singaporean regulators who happen to be very clear about what the rules are, and you don't have to worry about American regulators. But if you what's called Nexus in the U.S., then you do have to worry that they will cross those borders and somehow affect you. As I mentioned earlier, and another thing, and one of the reasons that we see so many crypto projects not being founded in the United States, we're seeing them founded even by American founders offshore, is because U.S. regulators tend to, so far, have not been very clear about what is okay and what is not okay. And that lack of clarity is, in fact, one of the things that caused a problem in 2017. The SEC retroactively decided that a lot of the utility tokens that were issued during ICOs were, in fact, security tokens. And the reason that distinction matters is because any kind of security has to be registered, both with the SEC, i.e. the regulator in the country in which you're based, but also with every regulator in which you sell, in the country in which you sell that security. So imagine you're doing an ICO, you sell the security to people in 100 different jurisdictions. You are actually legally required to engage with the regulators in 100 jurisdictions, file paperwork, et cetera, et cetera. It's an incredibly expensive proposition. So lack of clarity and retroactive enforcement rules that weren't clear is a really big issue in the U.S. Singapore and Switzerland, for example, have been very clear about, and they draw a bright line and issue guidance about what is a security, what is not a security, what they would do in various situations. So even though those jurisdictions are very strict, it's pretty easy to figure out how to navigate them. The spectrum. We have jurisdictions like that are very popular with crypto protocols. We have Panama, we have Cayman Islands, we have BVI, and a few others where there are absolutely no restrictions on what can be done. Regulators don't get involved at all. That is slowly changing, and I believe that's changing because of pressure that's being put on those countries by, for instance, the United States. And so no one listening to this should assume that just because something was unregulated 6 months ago, that is still the case. It's always a good idea to check.
So like the underlying theme here is tremendous complication with the simple number of jurisdictions we have, along with the influence of the United States and how that is influencing a constantly evolving legal environment here. I think one thing folks would be really interested in understanding is about tax. How does it get paid? What are the implications of setting up some of these decentralized organizations? That kind of thing.
Okay, so again, I'm going to talk about this from the perspective of the United States. I'll start from that perspective, and I need to talk about tax in two different ways, from two different perspectives, from the corporate perspective as well as the individual perspective, both of which are very, very important to founders of protocols or any kind of crypto project. So the United States does not tax corporate entities extraterritorially, i.e. outside of the United States, unless they can prove some link to people in the United States, either shareholders or directors. And there are some subtleties around what that proof has to be and how those two things are treated. But that's sort of too in the weeds for this discussion. From a personal perspective, anybody who's involved in projects who is earning crypto or either being paid in crypto or has crypto vesting as part of their compensation package needs to worry their U.S. taxes. Now, even though the U.S. doesn't tax corporations extraterritorially, they do tax individuals extraterritorially. If you're lucky enough to have an American passport, you are also lucky enough to be a citizen of 2 countries on the planet that will tax you no matter where you live. We think that's normal. Nobody else thinks that's normal. The standard in the world is you pay tax wherever you happen to live. So you may be a resident in Guatemala working on a crypto project. If you have an American passport, you still need to pay attention to how Uncle Sam is going to be taxing your crypto revenues.
Do you mind explaining in just a little bit more detail what Nexus is? Because I know you've said that a few times, and it seems to be inextricably linked with what Uncle Sam wants to do, who they want to determine somebody that they can tax.
Okay, so Nexus is a really broad term that in traditional commerce means presence. So, for example, you may remember that in the early days of Amazon, depending on where you lived, you either did or did not pay tax, local tax when you purchase something. That wasn't true, for instance, if you were in New York State, because Amazon had offices and facilities in New York State. In Washington State. Therefore, anybody who got an Amazon delivery had to pay Washington State tax. But if you were in Connecticut, where they didn't happen to have a warehouse or offices, you didn't have to pay. So needless to say, a lot of state governments got upset about that sort of thing. Eventually, Amazon got big enough that they had some sort of presence or nexus in just about every state. And then the way that they handled this changed, and they decided they were just going to charge tax on their places or where they lived. In this case, it was actually to their advantage because that's an incredibly complicated thing to do, and smaller retailers couldn't do it. It was just too expensive. Although I bet there's a service you can buy from Amazon that will help you figure out what you should be charging people depending on their zip code. So that's one example of Nexus. Another may simply be where you have employees, where work is being done, where you have a registered office. These are depending on your jurisdiction, you really need to talk to lawyers to understand what what could cause either a tax authority or a regulatory authority to have jurisdiction. So for that reason, Nexus is incredibly important. There's a related concept called substance, which you may run into, which is the fact that you have established a presence. And this is important if you set up your project offshore and need to make sure that the project is actually considered to be offshore by another country. So in that case, there may be what's called a substance requirement. That is that you need to have a presence in the jurisdiction in which you're trying to establish the project, and it has to be a provable presence. So either founders need to live there, or founders need to spend a significant amount of time there, or the company has to have an office, or the company has to have directors there. And because otherwise, some jurisdictions will just consider that a shell and will ignore the fact that it exists and try to claim control over that business.
It makes a lot of sense. So a little bit in the same vein, I'd love to ask you if a project does decide to incorporate itself offshore, what are some of the things beyond Nexus that they should be considering?
Beyond Nexus, well, somehow everything tends to Nexus can be established in so many different ways, and it will be considered from multiple points of view. And another thing that you need to worry about, again, depending on your jurisdiction, is whether there's a conflict in the way regulatory authorities and tax authorities might treat your business, or, you know, in our specific case, our token. So when we were setting up the Credmark project, I had to meet separately with legal teams that dealt with regulators and legal teams that dealt with tax authorities. And they spoke completely different languages, because the SEC will consider most tokens securities, whereas the IRS will consider them commodities. Because if the IRS considered them securities, they wouldn't be able to tax them the same way. And if the SEC considered them commodities, then they would have no jurisdiction over them. So it's pretty interesting that you can be dealing with two different federal agencies, and they look at you as completely different things.
Yeah, this is an undoubtedly complex space that requires a lot of thinking through. A lot of things to figure out. How did Credmark go about it in advance their IDO and setting up the DAO?
So we started off doing it what I would consider wrong. we were in a rush. The first thing we did was actually a very good thing, which is we taught other people in the space who had recently launched projects and asked them about how they had structured things. That turned out to give us a framework and some really useful guideposts. What we didn't do, which was really important, was then go double check that all of those things that had been done were still valid. And as I mentioned a few minutes ago, rules change, and they change really fast. So we put things in place that had been the right thing to do 6 months prior, but by the time we did them were the wrong things to do. And luckily, we discovered these mistakes fairly quickly, and were able to correct them, which is lucky, because sometimes these things take a lot of time to unwind. The best piece of advice I can give anyone looking at this sort of thing is to make sure you speak to lawyers in every single jurisdiction that your project is going to touch. Every jurisdiction in which you have people working on the project as direct employees, it's less important if they're contractors, but even then, if they don't meet the qualifications of contractor in wherever you're based, you should consider them employees. So you need to pay attention to them. I mean, as an example, Singapore is very strict about what a contractor is. And most contractors do not fall into the contractor bucket as far as the Singaporean authorities are concerned. They're actually employees. Other jurisdictions are much more lenient about that sort of thing. In our case, we hired a law firm that is global and that has representatives in all the jurisdictions that we care about. This has turned out to be very, very useful because it allows us to have a primary point of contact, a head lawyer who then connects us and coordinates the work of teams in other places. Another thing to keep in mind is how crypto savvy the lawyer or who is your primary advisor actually is. A lot of the big firms don't have very mature crypto practices. No crypto practice is going to be older than 2016, basically. But if someone has established one back in 2016 and has the scars from the ICO phase, chances are they really know what they're talking about. And the reason this is important is because a lot of the things that they have to figure out from a legal and financial perspective, they only figure out because they see not one or two projects, they see hundreds of projects. So they have way more information than any one of us in the space can have individually.
That makes a lot of sense. That's really good to hear, Paul. So we've just got a few minutes left. I think one more question is, what's the biggest piece of advice you'd give to somebody thinking about starting their own DeFi project or protocol, getting involved in the space?
The first thing is talk to other founders, find out what they did, how they did it, and when they did it, and then find out who their lawyer is, get feedback on the best crypto practices in your particular jurisdiction. When we got started, I interviewed 4 different law firms, and they were pretty in-depth interviews. I really cared about how much work they had done, what kind of recommendations third parties gave, et cetera, et cetera. At the end of the day, you need to spend the money because this isn't something that a normal person, no matter how smart they are, is going to be able to figure out on their own. You really need a lot of history. You have to see a lot of water go under the bridge, and you have to be really plugged in to the constantly shifting environment. And I have to say, I've worked outside of crypto. Obviously, I wasn't born yesterday, and I haven't seen any environment that is changing as quickly as this one.
Good, Paul. That's excellent advice. I think anybody thinking about getting involved in the space would benefit from it. We're about out of time. Thank you very much. And to anybody listening, we'll get this posted up on our page with the other AMAs we're doing as part of our idea.